Here's a question for you. You're on trial for first-degree murder. You're facing life in prison without the possibility of parole. And sitting in that jury box, one of the 12 people who will decide whether you ever see the outside of a prison wall again is a man whose son-in-law works for the prosecutor trying your case. Not in law enforcement, not in the county, for the actual district attorney in his office under his direct supervision. Your lawyer stands up and says, "Judge, this juror has a family member working for the other side. He's got to go." And the judge says, "Nah, let me think about it over the weekend." That juror stays, that juror deliberates, that juror convicts. Now, before I tell you what happened next, let me tell you who we're talking about. Letecia Stauch is accused of stabbing, actually, at this point, convicted, now reversed, not convicted, but accused of stabbing her 11-year-old stepson, Gannon Stauch, 18 times, beating him with a blunt object, shooting him with a pew-pew in his head, stuffing his body in a suitcase and dumping it under a bridge in the Florida Panhandle. At sentencing, the judge called it the most horrific case he had ever seen. Now, I want to be absolutely clear with you right now. Letecia Stauch is a monster. What she did to that little boy is evil. I have zero sympathy for her, none. And nothing I say tonight should be taken as sympathy for what she did. But yesterday, the Colorado Court of Appeals said it doesn't matter. Murder conviction reversed, life sentence vacated, new trial ordered. Because the Sixth Amendment to the United States Constitution does not say you have the right to an impartial jury, unless you're really, really guilty. It does not say you get a fair trial unless the crime makes people sick. It says you get a fair trial, period. And that right applies to every citizen, the best of us and the absolute worst of us. Because the day we start deciding that some people are just too evil to deserve constitutional protection is the day those protections stop meaning anything for anyone. Tonight, we're going to walk through the entire opinion. I'm going to show it to you on the screen, and I'm going to explain what happened, why it happened, and what comes next. And I'm going to tell you why one of the three judges thinks that this was wrong. So without further ado, let's jump in to the opinion in the Letecia Stauch murder case. Hello, beautiful humans. Happy Friday evening. It is April 3rd, 2026. I am Bob Mata. This is Defense Diaries. And we're celebrating a bit here. I'm so sad my beautiful and brilliant co-host won't be with me tonight because she's still working on this thing. So it's going to be me solo. I'm going to have to celebrate with my chosen family, y'all, our beautiful community, as we go through this nightmare scenario that just as we were sitting there going through, I think it was day 13 of Zach Adams' original trial in 2017, the news dropped that Stauch was getting a new trial, and it kind of blew my mind. So I spent the day where I did want to come and do day 14. I had to read the opinion and I had to prepare for this live tonight. So sadly, I pushed that. Depending on what time we pick Scarlett up from the airport tomorrow, I might do a live, late morning live for the Zach Adams case tomorrow. But what I want to do here tonight is kind of go through it. I know there's a lot of people that are just horrified at the concept of what's going on. But the reality is that the right thing happened. As hard as that is, as bitter of a pill as that is to swallow, the right thing happened. And at the end of this live, you'll know why, and you'll understand why. I have a feeling that a vast majority of you here already know why and why it matters, because we pounded over your head. Sixth Amendment, man. That's the absolute key to this thing. But we're going to dig into it in the way that we're going to do it. I'm going to pull up the document at this point, and then what we'll do is we'll go through it. We'll check it out. We'll see what's what. And hopefully it's going to be interesting, informing, and somewhat entertaining. We'll see. We'll see how it plays out. All right, let's get this guy up there. Make it bigger for y'all. And we're going to do this in a way that is kind of going through it from beginning to end, because the dissent is interesting. And when we get to it, you'll see the dissent is really the reason why I think that the Supreme Court, the Colorado Supreme Court, is going to take this case on, and they're going to look at it, because it is an issue, a first plus issue. It's not an issue that's been raised before the court, so there's no precedent for it. And it's important enough that I think the Colorado Supreme Court's going to accept the appeal from the state, and they're going to take a look at it. But at the end of the day, the moral of this story is, like I'm always saying, that we need to get it right the first time, because to put the family through a second trial of this nature is just cruel. And it was completely avoidable. You'll see. It was absolutely avoidable. This wasn't a thing where people didn't know what was going on. The judge, bottom line, just shit the bed, plain and simple. There's absolutely no way around that. And in the state, if you were to ask Michael Osbrook, he likes to say it was the prosecutor that they knew, and that he puts it on them. And it's really, they're the ones who have to retry the case. They're the ones that have to go to the family and explain, I probably should have bounced that juror, and because I knew what the rule was. And it's a hard and fast rule. We're going to get into it. But before we do that, before we get into the deep nitty gritty, thank you, all of you out there. We hit 65K. Nice landmark. It's a beautiful, beautiful thing. I think we hit it, like, I don't know what time Tracy texted me. It was probably around midnight or maybe 10:30, somewhere late evening. And she hit me up. She's like, we hit 65K. So Allie and I probably said it best in the community page, where I wrote a love letter to y'all. Just expressing how much we love you guys and how much you guys mean to us. And, that thing that I say at the end of every show, that, without you guys, I'm just an old man talking about a bunch of cases, is the absolute truth. Because without the community, it's 65, Peppermint, not 60. Don't be short shifting us 5K. Yeah, 65,000. It's a big number. It's a big number. You know how Allie is with that 100,000 thing, but it's baby steps. But I feel like when we're getting closer to 100 than we are not being close to it. So I'm really, really excited about it. And we just couldn't do it without you guys, without your love and support. It's everything that makes the channel what it is. It makes the community what it is. We've up and built an actual community with people that have become friends in the chat, to Allie and I, to one another. It's an amazing thing. It's like that thing that I just didn't think about when talking to myself in my head about starting a YouTube channel. I was like, my goal was to really just market the podcast, the audio podcast. And little did I realize I would fall in love with the format like I did. And little did I realize that we would start building this community of amazing people that I just love spending the day with, and it's like, I'm way more guilty of reading the chat during lives than Allie is, because I value you guys. I want to see what you're saying. I love our chat. It's like, I try to be super, super attentive to chat, because it's amazing. You really are the best community out there. Like I said, I'll cage match anybody who wants to fight over who has the best community. And the channels of the size to where everybody can still be, seen and heard, which is significant. You get into a channel and you've got 15,000 people in there and the chat's going a million miles an hour. You're not seeing anything. There's no actual communication going. So thank you guys a million times over. We just adore you. Your love and support, your financial support of the channel is everything for us. It's literally what allows me to do this. Otherwise, I have to hang it up and go practice law again. And I really don't want to do that. I have a much louder voice here to the masses than I do in a courtroom. And I'm trying to do good out here. I'm trying to educate people. I'm trying to get people to listen, to learn. I'm really not trying to pound anything over anybody's head other than the fact that the Constitution matters for all of us. It's the backbone of this country. Without it, we're rudderless. We're floating. We're out in space, untethered. We need it. We need it desperately. And every day you see why we need it so much when they're attacking free speech, when they're attacking our rights. I mean, we have to protect it at all costs. And if you don't know what it means, it's hard to be passionate about it. So we've taken it as our mission to educate people, not only about defense attorneys and how we are the only protectors of the Constitution, because it's not the government, it's not the police, it's not the judges, it's not the prosecutors. They are the government. The document was written to tell the government what you cannot do with respect to us as the citizens. So, and there's only one group of folks out there that's fighting for it. And as you guys know, at this point, it's defense attorneys. So, and it's been like, I consider us to be in the golden age, kind of the renaissance of defense attorneys. We've had so many cases popping up recently where it's just shined a spotlight, incredibly bright spotlight on just how important, how critical defense attorneys are. You start with Karen Reed, you go to Kelsey Fitzsimmons. I mean, it's case after case after case where you see why we need defense attorneys, and you see how hard of a fight it is to beat the government, because they have the power, they have the resources, they have all the advantages, and it's a battle. So we love you guys so very much. And like I say every time, the bottom line is, without you guys, we wouldn't be here. So thank you over and over and over again. We love you with all of our hearts. We appreciate it. All right, let's start digging into this thing. So yesterday, huge decision coming out of Colorado. Now, I kind of want to, for those who might not be familiar with the case, I want to kind of give you a bit of a refresher. And this is, I'm going to throw it out there. I know in the cold opening that I had it in there in terms of what exactly this woman did to this poor child. But we're going to kind of get into it a little bit more. So just, if it's triggering for you, just step away for a few minutes. I'll be done with the background, and then we'll get to the law portion of it. And then your mental health will be protected. If you know what's up, stick around. We'll get through this, and then we'll dig in. So Gannon Stauch was an 11-year-old boy living in Lorson Ranch near Colorado Springs with his dad, Al Stauch, and his stepmother, Letecia Stauch. And on January 27th of 2022, Letecia called police and reported that Gannon had left the house on foot and hadn't come back. And over 200 volunteers, of course, because there's good people out there, they show up and they search for the kid. So almost immediately, things start falling apart for Letecia. She refuses to cooperate with the cops. She couldn't account for her whereabouts on the day that Gannon supposedly vanished. She called in sick to work for completely unrelated reasons. She's texting family members, posting on Facebook, but won't sit down with the cops investigating her stepson's disappearance. Fast forward 2 days later, She finally goes to the police station. And at that point, she completely changes her story. First, it was, oh, he went off to a friend's house and didn't come back. Now, 2 days later, she's saying that Gannon was abducted by a carpet repairman who sexually or essayed her at gunpoint. Meanwhile, the cops find a roll of carpet with blood on the inside of it in a storage area in her house. Fast forward to a few weeks later, Gannon's body is discovered underneath a bridge in Pensacola, Florida, in a suitcase. The prosecution's evidence showed that Stauch stabbed this child 18 times, beat him with a blunt object, pew-pewed him in the head, hid his body in a suitcase in the basement, moved it to the Colorado Springs Airport parking lot, then to a wooded area near Palmer Lake, and then finally drove it to Florida and threw it off a bridge. It's a lot to digest. It's a lot to digest. The depths of evil that type of crime encapsulates is breathtaking, truly. Skip to trial. She pleads not guilty by reason of insanity, claiming that she had suffered from a dissociative identity disorder, and the jury rejected that defense and convicted her on every single count. First-degree murder after deliberation, first-degree murder of a child under 12 by a person in a position of trust, tampering with the deceased body, tampering with physical evidence, and multiple crimes of violence enhancers. The judge gave her 2 life sentences without parole, plus 12 years for the body tampering and 18 months for the evidence tampering, all to run consecutive. So look, let's be real about what we're dealing with here. The evidence of what this woman did is overwhelming, and it's horrific. Nobody is disputing that. The question this opinion answers is not, did she do it? The question is, did she get a constitutionally fair trial? And the answer, according to 2 out of the 3 appellate court judges, is no. Simple as that. So let's figure out what went wrong. And this is where we're going to turn to the document. So what actually happened, the real problem in this case happened during jury selection. And that's where this entire case turns. And I'm going to get over here to page 4. So before trial, the way that this went down is prospective jurors filled out a jury questionnaire. Very common. Most jurisdictions do it. One question asked whether or not the prospective juror had friends or family in law enforcement. A prospective juror, and the court refers to him as Juror MB, indicated that his son-in-law worked with the El Paso County District Attorney's Office. So during follow-up questioning, MB confirmed that his son-in-law was a deputy DA working in the same office as and directly for Michael Allen. Now, Michael Allen was the elected DA of El Paso County, and Michael Allen was the prosecuting attorney, the attorney of record on this case. So we're not talking about a juror who, say, had a cousin who's a beat cop. We're talking about a juror whose son-in-law works for the guy trying to put the defendant in prison for the rest of her life. Now, this is where we want to get into what I've got up on the screen here. All right. And this is the distinction between what they call implied bias and actual bias. Okay. Now, I want to explain a legal concept that's absolutely critical to understanding this opinion. And it's the difference between implied bias and actual bias. If you understand this distinction, then everything else falls into place. All right. So it starts right here. And this is what Osbrook was talking about yesterday. He had tweeted, he's like, oh, I'm putting it on the prosecutor. You know, the prosecutor knew. He knew the rule. So Colorado has a statute, which is right in front of you here on the screen. Okay. Let me make it a little bigger for y'all so that you can see it. Okay. So section 16-10-103, and it lists the reasons that a juror must be removed for cause. Now, 2 of them matter here. Okay. We've got subsection 1B that says a juror must be removed if they are related within 3 degrees to any attorney of record in the case. 3 degrees of relation covers your parents, your children, your grandchildren, siblings, aunts, uncles, nieces, nephews, and in-laws at each of those levels. So a son-in-law is within 3 degrees. Now, this is what we call implied bias. And with implied bias, the law doesn't ask, can you still be fair? It's that thing that I'm constantly talking about every time we're talking about rehabilitating a jury or a juror. Like we were just talking about it recently, where that thing where the judge says, oh, can you put aside your bias and can you only focus on the facts in the law? And if that juror says yes, and the judge believes him, that juror is rehabilitated. Now, I always call BS on that, but what I think doesn't matter because the person in the black robe runs the court and runs the trial. So that is implied bias. And again, if you're related to someone in the prosecutor's office within 3 degrees, the legislature has decided that you are biased as a matter of law. You're out. You cannot be rehabilitated. There is no follow-up question that fixes it. Okay. Think of it like a disqualification in a sporting event. You know, you see players get in a fight or you see them do something dirty. That player doesn't get to go and argue that they can still play fair. No, the rule says you're out. Same deal here. Okay. And then there's section 1J. Okay. And 1J, this deals with actual bias. Now, that's where a juror has a state of mind showing enmity or bias. Enmity is like deep-seated hatred or bias, okay? And that's one where somebody says something like, you know what? I think the insanity defense is, I think they're a scam. Like, I think these people are all lying and they're just trying to get out of it. Or I could never be fair in a child abuse case because it infuriates me. And even the thought of it, there's no way I'll be able to sit on this jury. So with actual bias, a juror can be rehabilitated. The judge in those situations can ask follow-up questions. Can you set that aside? Can you follow the law? And if the juror says yes, then the judge says, okay, well, you know what? I believe you. You can stay. So implied bias doesn't work that way. There is no rehabilitation. I'm going to say that again. So you've got actual bias where the person comes in and they're biased for whatever reason, and the judge can ask those follow-up questions where it's implied, such as you're related to the prosecutor. There is no rehabilitation. The word in the statute is shall. The court shall sustain the challenge, not may, not can consider, shall. Shall is one of the strongest words in the law. That means you're doing it. There's no choice. The judge, you're doing it. You shall do this. So, and here's the thing. This isn't new law. The Colorado Supreme Court had decided that this exact issue in 1992 in a case called People versus McCrander. All right, let me get to that. Let me shrink this down a little bit. Not quite that much. All right, so in People v. McCrander, they held that when the elected DA is the attorney of record, the automatic removal statute covers not just jurors related to the elected DA, but jurors related to any deputy DA, which is what we have here in the entire office. Any of them. Doesn't matter if the deputy DA appeared in court, participated in the case, or even knew that the case existed. If a juror is related to anyone in that office within 3 degrees, they're out. It's as simple as that. It's a bright line rule. That's it. The whole point of the rule, as the court put it, is to preserve the appearance, if not the reality, of fairness in a criminal prosecution. All right. So here's what goes wrong at trial. All right. And they, the opinion's great because they literally pull from the transcripts. Okay. And we're gonna be able to see exactly how it went down. Okay. Let's see, where is it? So this is where it starts. Okay. So this is the colloquy. All right. So again, remember, this is during voir dire. All right. And it starts with the defense counsel challenges MB for cause. Okay. And when the judge asks why, the defense attorney says, and this is a direct quote, yeah, his son-in-law works for Mr. Allen. Simple. It's clean. That's a relationship challenge under subsection 1B, the first one that we went over. Now, here's what's interesting. The prosecutor, and this is where I think that they really dropped the ball, initially says, and this is again quoted, I hate to agree with the defense counsel, but the follow-up questions were never asked. How is that going to impact his ability to be a fair and impartial juror? That's the prosecutor acknowledging that they're in actual bias territory and there's no foundation's been laid. But then the prosecutor pivots and says the challenge certainly doesn't rise to the level of a statutory cause. And here, like, I don't know if this prosecutor is just playing stupid or just doesn't understand the law, because that wasn't an actual bias analysis at all. As soon as the defense attorney says, the elected DA's son-in-law works for the office, and we're talking about as to this juror, it's done. That's done. It's over. It's implied bias. No questions are to be asked. It's over. The judge. So, like I said, Osbrook likes to put it on the prosecutor. I put it on the judge. It was the judge. The defense made the argument. They raised the issue. The judge, if the judge wasn't aware of the rule, he should have opened the rule book. Should have looked at the statute, because it's unambiguous. It couldn't be more clear. 3 degrees. It's done. Gone. Bye. We have other jurors. Take care. That happens. We're not here. Understand that. Instead, what happens, the court agrees with the prosecutor. Okay. And the judge says, I don't think it's a statutory cause. He says that he needs to think about it over the weekend. So, to make matters worse, not only does the judge whiff initially, he then has the entire weekend to think about it. And more importantly, to look up the law. That clearly didn't happen. So instead, when they get back to court on Monday, brings MB back and he asks a few follow-up questions about whether MB has discussed the case with his son-in-law or would be influenced. Based on those answers, the court keeps MB on. Now, what should have happened? Should there have been any follow-up questions allowed? Chat? No, of course not, because it's a clear, unambiguous rule. And there's your error. It's a structural error, because under subsection 1B, you don't get to ask those follow-up questions. The relationship itself is the disqualification. The follow-up questions are for actual bias under subsection J. Remember that thing where, like, oh, I can't sit on an essay case, or, I could never sit on this jury because I could never do this or do that because of certain beliefs that I have. Like, those are actual bias where you can probe, you can ask questions to see if you can rehabilitate that juror. This is not that. By asking those questions and keeping MB on, the judge treated an implied bias challenge as if it were an actual bias challenge, and that's just flat out wrong. It's wrong. Judge massively screwed up. So the Attorney General's office on appeal Didn't even try to argue that MB didn't fall within the statute. They conceded that point because the law is clear. Plain and simple, the judge just got it wrong. So let's talk a little bit about what structural error is and why this is not a technicality. I've seen it out there on Twitter, using that word that I can't stand in relation to the Constitution. It's a technicality. No, it's not a technicality. It's constitutional. It's a constitutional question. It's a constitutional issue. So, and I get it in chat, like it disgusts everybody. The concept of this happening is disgusting. It's repugnant. You're thinking to yourself, my God, she murdered a child. She murdered an 11-year-old boy. She gets a new trial because of a juror. That feels like a technicality to me. It's not. And I hear you. And I feel the same anger that you feel about what she did to Gannon. That little boy was failed by the one person who was supposed to protect him when his father wasn't home. What she did is evil. There's no other word for it. Plain and simple. And his family, his mother, Landon, his father, Al, his grandmother, none of them deserve to go through this again. But I need you to hear me on this. A conviction obtained through an unfair process is not justice. It's a shortcut. And shortcuts in criminal law don't just affect the monster sitting at the defense table today. They set the rules for the innocent person sitting there tomorrow, or for you, or for somebody that you love. Because the Sixth Amendment guarantees the right to an impartial jury. It doesn't say an impartial jury unless the crime makes your stomach turn. It doesn't say an impartial jury unless the defendant is clearly guilty. It applies to every single citizen, regardless of how despicable they are or how horrific the crime is. And here's the hard truth. The more repugnant the crime, the more important the right becomes, because those are the cases where the pressure to convict is the highest. Those are the cases where the temptation to cut corners is the greatest. Does that make sense? Those are the cases where we need the guardrails the most. That's not me being sympathetic to Letecia Stauch. Trust me, she can rot in hell. That's how I feel about her. This is me being protective of the constitutional right that belongs to every single one of us. So, as far as explaining the legal framework, it's important because it matters. All right. In appellate law, all right, let me get down here. We have two categories of trial errors. Okay. So most errors are what we call harmless error, and that's the judge made a mistake. But when you look at the whole trial, that mistake probably didn't change the outcome. So there you can have the appellate court say, you know what? Yeah, the judge screwed up here, but when we look at the totality of the evidence and what was put before that jury, that error didn't have any impact on that verdict because there was so much. So therefore, there was an error made, but it's harmless. Okay, so an appellate court can say, yeah, look, that ruling was wrong, but the evidence was just massively overwhelming. Okay. Those errors do not get you a new trial. They just don't. But then there's structural error. And structural error is the nuclear option. It means the error was so fundamental, so baked into the framework of the trial itself that you can't even begin to measure its effect. You don't get to do a harmless error analysis. You don't get to say that the evidence was strong. The conviction is reversed automatically. No questions asked. That's what structural error is. All right. I want to get here. So one of the cases they cite. So the Colorado Supreme Court held in a case called Abu-Nantambu-El in 2019. Okay. And that when a trial court erroneously denied a challenge for cause and a biased juror serves on the jury, that the error is structural and requires reversal. And the reasoning makes sense. Okay. So a biased juror doesn't affect just one piece of evidence or one witness. That bias is like a cancer. It infects every moment of the trial. So every piece of evidence that juror hears, every argument, every deliberation, every conversation in the jury room, it's all tainted. It's like the equivalent of taking like a drop of ink and dropping into water. Okay. And the water just, you've done it before. When you're dyeing your Easter eggs, put that tablet in there. You can't unmix it. It's done. Once it's in, it's in. All right, let me get to page 16 here. So the court here quotes language that the harm from a biased adjudicator, quote, pervades let me find it. All right, so the pervades and infects the entire framework of a trial, and that maintaining the integrity of the judicial process is in the interest of not just the accused, but of the public. And that's you guys. That's all of us. This principle doesn't exist to protect Letecia Stauch. Frankly, she doesn't deserve our sympathy or our concern, if we're being honest. The principle exists to protect the system. Because the moment we start saying that this person is too evil to deserve a fair trial, that right stops meaning anything for anybody. That's why this matters. So as far as the Attorney General and the way that they handled it, now remember, defendant appeals, the Attorney General, much like in the Richard Allen case, handles the response brief. Okay. And so here the Attorney General threw everything at the wall to avoid dealing with the merits of the claim. The merits being, judge screwed up. This is implied bias. There's a statute regarding implied bias. This wasn't a decision. This was a, you do this. That juror is gone. Plain and simple. So, but let me walk you through the arguments, because this is like an absolute masterclass in how the state tries to dodge a losing issue on the substance by attacking the procedure. All right. Okay. Okay, let me get to 15 here. All right. So first, the AG argues the defense counsel didn't properly preserve the challenge because he didn't cite section 1610-1031B by its number. So he actually makes that argument. Now, this is different if we're thinking about the Richard Allen case, where we have the same issue of waiver and the two issues that Andrea and Allie argued against Osbrook, who was the state, that they didn't preserve issues because they didn't object at trial to certain things, and that the rule is hard and fast in Indiana as to that, in that if you don't object to trial, no matter if you'd objected previously or filed a motion, if you don't restate it at trial, it's waived for the purposes of appeal. So here the AG just is claiming, look, all the defense counsel did is said his son-in-law works for Mr. Allen. That's not enough. That's what the AG is saying. So the appellate court turns around and says, look, like you don't need talismanic language, like magical language here. Like the number isn't the magic. Citing the statute number isn't what makes it the law. You don't have to cite it chapter and verse. You just need to give the trial court the opportunity to rule on the issue. And the issue is when a defense lawyer says, hey, judge, this juror's son-in-law works for the DA who's prosecuting my client. At that point, the issue's obvious. And in the opinion, the court contrasts how defense counsel challenged MB versus how he challenged a different juror. Okay, so juror number 8. Let me find it. We're getting into it here. Okay, you can see it down in footnote 3 down there. So in this portion of it, with juror number 8, counsel went through a long list. Okay, and you'll see immediately, now knowing the difference between implied bias and actual bias, when the defense counsel during voir dire, when you're asking the questions of the jurors, asks things like, you can't be fair in a child abuse case. You can't set aside what he's heard, thinks the insanity pleas are a scam. All of that, again, is actual bias. It's your state of mind. But for MB, just saying his son-in-law works for Mr. Allen, that tells you everything that you know about the nature of the challenge. Okay. And so footnote 3 reads as follows, the record further supporting this reading. So in addition to juror MB, defense counsel identified juror number 8 among the jurors that he wished to challenge for cause. He explained that juror number 8 had indicated on his questionnaire that he could not be fair in a case involving CA and was not sure that he could set aside information he had heard about the case. Believed not guilty by reason of insanity plea was a ploy to excuse the alleged crime and was never asked about any of that. By contrast, when he asked for his basis for challenging juror MB for cause, defense counsel simply said, yeah, his son-in-law works for Mr. Allen. So the appellate court put that out for a reason, to show the difference when you've got an attorney challenging for cause when they're clearly talking about actual bias, and that this actual bias rises to the level that there's no way that this person should be sitting on this jury because they're just too biased. But in that situation, again, the judge gets to ask those follow-ups. I understand that you feel this way and this way and this way about these things. However, can you set that aside? Can you follow the law? And if that juror says yes, and the judge believes that juror, judge isn't going to strike that juror for cause. It's just not. They're going to say, okay, putting him back in the pool. He's good, no cause. And we're going to get into cause and peremptory challenges in a little bit, because I want you to understand all of the process. So the AG then goes on to make a second argument, which was that the defense counsel's follow-up comments where he said that this would be different if the son-in-law had worked for the police or a different DA's office, showed the challenge was really about actual bias, not implied bias. Now, the court rejected that completely rejected that. Okay. Those follow-up comments came after the trial court had already indicated that it was going to deny the implied bias challenge. So defense counsel was trying a different angle, which is what a good lawyer should do. You don't hear no and just give up. You try to go a different route. And the court said that doesn't somehow magically erase the first challenge, which is this dude works for the DA trying this case. And that makes perfect sense, right? So the heart of this particular fight on this issue, in this case, in this appeal, is that, and this is where two of the judges disagree with the third judge, because there is a dissenting opinion. Okay. And if you're going to remember any takeaway from this particular live tonight, it's this portion of it, because it's kind of how the sausage is made. All right. And ultimately, again, I'll get into it in a bit, but why I think this thing is ripe for the Colorado Supreme Court to listen to it and chime in. So it's important, and I think most of you probably know, but I can't assume that all of you know. When you're picking a jury, you basically have two different tools. Okay. And tool number one is what we've been talking about, which is a challenge for cause. Okay. And that's where you're telling the judge, look, judge, this juror has a legal disqualification. Like, say, for instance, a relationship with the prosecutor. There's a stated bias. There's something that the statute says is a problem. And if the judge agrees, the juror's gone. And here's the thing about cause challenges, they're unlimited. They're unlimited. You could try to get rid of as many jurors as you want with a cause argument. In my experience, they rarely work. I mean, there's got to be some real implied bias or a statute in place where your facts fit neatly into that statute and the judge has no choice. Because most of the time, the judges think that they can rehabilitate jurors, because judges feel that jurors take their civic duty very, very seriously. And that even though they may have come in with a bias one way or another, whether it be through a high publicity case and learning about the facts, forming an opinion, or learning what type of case it is, and they have history in their personal life that happens to revolve around that same type of crime, which creates a real issue in that juror's mind in terms of not being biased because they feel a certain way about it. I mean, those are real things that, and you've heard my opinion on that. The judge asking a couple of questions about being able to set something aside, to me, is utter garbage. It's not how we operate as human beings. Whatever that bias is, it survives that question. Can you set that aside? But the judges like to think, because the jurors take this civic duty so seriously, that they will be able to actually block out all their bias and just focus on the law. And maybe that's true for some people. I'm sure it is. But as a general proposition, not a chance. It's just not realistic. That's one of the frustrating things about the law, is that a lot of times it seems like it's not based in reality, but kind of in legal fictions. It's one of the things that I just always had a really hard time reconciling, practicing, because it would drive me nuts. You know, it's like I would be up there making that same argument that I basically just made. I'm like, Judge, this person just walked in and told us they think our client's guilty. You think you asking that question, whether or not they can set that aside, is actually going to work? It's not. It's not going to work, you know? And then the judge will say, well, counselor, you're going to have to use tool number two. And tool number two is the peremptory challenges. Okay. Now, a peremptory challenge is a freebie. Each side gets them. And you can use it to remove a juror for almost any reason. Their body language, they give an answer you hate, their vibe, whatever. I find something in their socials, I'm like, oh, I don't want this person on the jury. But here's the rub: you only get a limited number. Now, in this case, Letecia Stauch got 16 peremptory challenges. And every single criminal defense attorney will tell you peremptory challenges are absolute gold. It's the most valuable currency that exists in jury selection. And frankly, I can never have enough. If they would give me 100, I'd take 100. And every one that you spend on a jury who should have been removed for cause is one that you can't use on somebody else who happens to make you nervous as hell. You understand what I'm saying? If I tried to get somebody for cause because of their bias and we step up, the judge asks the questions, person says, yes, I can put it aside, just says, well, I believe you. You're rehabilitated. Back in the pool you go. I've lost the cause challenge. That's a person that I know to be biased in all the things that I just talked about that are going through my head about the reality of whether somebody could put that aside. I've got to get rid of that person because I don't believe that. I don't believe that they've been rehabilitated. So I have to use one of my challenges to get rid of them. Now I'm down a challenge. So what happened here is the judge denied the for-cause challenge to MB, as we heard. And then Stauch's lawyers then used all 16 of their peremptory challenges. 7 of them went to other jurors who had been challenged for cause and were denied. Okay, that's a lot of rehabilitated jurors, right? It's a lot. 9 went to the other jurors that they wanted off for various reasons. But here's the rub. Here's where the issue is. What they didn't use in terms of MB is one of their peremptory challenges. So what I'm saying to you, and the dissent gets into this heavily. The dissent it lives in this issue right here, which is MB, at the time that MB is brought in front of the judge on a cause challenge, the defense still has peremptories left. Okay. It's an important distinction, meaning that at the time that the MB challenge for cause took place, they weren't already out of peremptory challenges. They still had challenges left. And they didn't use one of them on that particular juror. Now, that could be for a million reasons. Most likely, the reason was that there were other jurors that gave even worse answers that they felt that they had to use the challenges on. So as a result, MB stays on the jury, he deliberates, and he's part of the verdict. So the AG's argument is exactly what I just said. Look, you had 16 challenges, bro. 16 peremptory challenges. You could have used one on MB. You chose not to. You waived it, buddy. Sorry. That's the exact issue that's going to go up to the Colorado Supreme Court. That's it. Now, in terms of the appellate court, they weren't buying it. They didn't feel that way. So you got the majority comes back, says, nah. And the majority flatly rejects that concept that the AG put out there. They rely on a line of Colorado court cases dating back to 2000. There's Morrison v. People, and this principle was born. A defendant is not required to use a peremptory challenge to clean up a judge's mistake. That's big precedent. That's precedent that the appellate court leaned heavily into. The defendant is not required to use one of their precious challenges to clean up a judge's mistake, because it's the judge's job to remove biased jurors. It's one of their functions. They're the gatekeepers of evidence. They have to remove biased jurors. We're trying to get a fair trial here. The judge is the boss. Flat out, it's not the defendant's problem to fix, it's the judge's. So in the majority really makes a practical observation that I think is devastating. You know, they point out that the state's position is absurd. You know, essentially saying, look, imagine you're the defense lawyer. The judge just denied your for-cause challenge. You think that the judge is wrong. Now you're supposed to go back to that same judge who's already denied you for cause and say, hey, judge, since you wrongly denied my challenge for cause, can I please have an extra peremptory challenge to clean up your mistake? I mean, how do you think that's going to go with the judge? The very same judge that just told you that MB doesn't need to be removed, and is that judge you think is going to give you an extra strike? I don't think so. It's not reality. It's just not realistic. It's not how this thing works. You know, it's like when you lose on a motion, whatever it may be, a motion to suppress, a motion to quash, any of the types of motions that we can file, and the judge rules against you, and then you file a motion to reconsider. Because there was either a change in circumstances or the judge misapplied the law. And there, you know, you're going to say, well, you know, here's our argument, judge. And it's the same concept. You're basically asking a judge to make an admission that they screwed up the first time. As you can imagine, that goes over like a lead balloon. Judges don't imagine the judge with the IT guy. Imagine trying to bring a motion for reconsideration in front of that guy. If you don't know what I'm talking about, go onto the interwebs and put in judge IT guy. You'll see this judge is unreal. But think about trying to go to a judge and saying, here, judge, I'm filing my motion to reconsider your ruling on that particular motion I filed. And imagine how that judge is going to react to that. He'll probably sanction you, which would be ridiculous. I'm saying that somewhat tongue in cheek, but it's a weird concept. It's kind of like the equivalent to me of whenever I hear about attorneys trying to remove a judge for bias. We saw it in Karen Reed. We've seen it in multiple trials. And instead of it going in front of a separate judge, for them to make the decision, say, okay, well, here's our evidence of bias. And then the judge can come in and say, well, I'm not biased. They can take the stand. When they have that judge being able to be the arbiter of whether or not they're biased, like we saw with Cannoni, is insane to me. I mean, I get the concept that the hope is that judges are going to be judicial. They're going to do what's in the best interest of the law. They're going to do what's in the best interest in terms of the defendant's rights. And that they'll say, well, you know, I really do think the son of a bitch did it. I am biased. You're right. I'm going to recuse myself from the case. Well done. Thanks for calling me out on that. It's not how it works in real life. That's like that pie in the sky shit. It's not how it's not how it goes. It's just not. I mean, is that to say that there's not a judge on the planet that wouldn't? Of course not. Yes, there's going to be judges that are phenomenal jurists and take that very seriously. And if they do come to realize you're right, thank you for pointing that out. I actually am pretty biased. I didn't realize it. It snuck up on me. But in order to preserve the defendant's rights, in order to make sure that this thing's not going to come back on appeal and torture the families of the victim again, so they have to go through a new trial, I'm going to recuse myself because it's the right thing to do. I'm sure that there's judges out there. I like to think that Judge Carol Erskine would do that. As a matter of fact, I'm completely confident that she would do that. You know, it's hard up on the bench. I mean, you're up there every day. If you're in criminal court or if you're dealing with abuse cases, I mean, you are hearing just nightmare after nightmare after nightmare after nightmare, day after day after day after day. You know, it's hard not to become jaded. It's hard to fight your bias because they're not robots. None of us are robots that work in the court system. We're all human beings. It's challenging. So here, again, the majority, which is the two judges, they really leaned into what I'm talking about here, talking about how courtrooms actually work. And the appellate court said, you know what? You know who else could have used a peremptory challenge on MB? Prosecutor. The DA could have. I mean, the prosecution certainly knew that this juror had a family connection to their office. This is where Osbrook lives. This is where Michael's like, I put it on that prosecutor because he damn well knew that this guy's son-in-law worked in his office. And that guy with the white hat should have been saying, you know what, in the interest of a clean trial, we're going to strike him ourselves. They didn't. So the state is arguing that the defense had to fix the problem, but the state was equally capable of fixing it. And you know what? They chose not to. So then we get into the dissent. I mean, like in terms of why the court did, it's like I said, it's a bright line rule. It's a bright line rule. It's structural error. It tainted the entire trial. And it was so avoidable. So avoidable. So the reason that I want to get into the dissent really is because of that question of what's going to happen with this thing afterwards. All right. So the appeal's taken place. Both sides briefed it. The appellate court's come down. They've reversed. They've vacated. They've remanded it. Now the state has the opportunity to go up to the Supreme Court in Colorado and say, look, you got to look at this thing. And the judge's dissent in this case really articulates why this issue, I think, is again going to get looked at and decided by the court. And it's interesting. There's a couple of interesting concepts here. So the dissenting judge was this Judge Bernard there. And he wrote a very forceful dissent. Okay. And even though I disagree with his conclusion, he does raise real points that real people are going to have to contend with up at the Supreme Court level. So Bernard in his starts with this hypothetical that you can see here. Okay. And he says, okay, imagine that the court wrongly denies a for-cause challenge to juror A and also denies challenges to jurors B through H. Okay. And the defendant has 16 peremptory challenges. She uses 7 to remove B through H. And then she uses the other 9 that she has left on jurors that she never challenged for cause. But for whatever reason, doesn't use one of those precious challenges to remove juror A, who they tried to get removed for cause. Juror A then sits on the jury, and then convicts the client. And what Bernard says, I got news for you. That's waiver. That is waiver. It's that situation exactly like I was talking about, wherein they had challenges when they went up and tried to get rid of MB for cause. They had challenges left. After they lost that, Bernard's arguing, okay, the fact that they knew that this guy had no business being on the jury, yet elected not to use one of their challenges to get that person who had no business being on the jury, you waive the issue. And if you watched our live about waiver, that means you can't bring it. You can't bring it up on appeal. Bernard's saying you had the tools. You made the choices. You chose to leave juror A on. And I mean, that is essentially what happened here. You can't argue it. It's what happened. Bernard continues on, goes even further into it. And he traces the history of peremptory challenges in Colorado and argues this issue, whether a defendant waives the error by not using a peremptory challenge to cure it, has never actually been decided by the Colorado Supreme Court. That's it right there. That's it right there. Whether a defendant waives the error by not using their peremptory challenge to cure it. It's a case of first impression. Hasn't been decided. Seems like it's something that should be decided, even though, again, I disagree with this judge. The defense should not have to cure the judge's error. The defense should not have to use their precious peremptory challenges to cure the prosecutor's error. Again, the prosecutor is the one that's trying the case. They have the burden. They're the ones who are going to have to go back and retry the case using taxpayers' money, using all of the resources that it takes to run a trial again, having to put the family of the victim through a second trial because they screwed up. The defense shouldn't have to use their tool, which they need, believe me. They need every one of those challenges. I have never gotten out of a trial and not felt like we needed more challenges. I have never gotten a jury where I'm like, this is the greatest jury of all time. There's always one or more jurors that I'm like, man, this is the lesser of two evils. Like, I don't love this person. And again, it's surface level shit. I don't know that person from a hole in the ground, but in terms of the way they answer questions, again, that vibe thing, all the different things that go into the art of trying to pick a jury. I've never felt comfortable with an entire jury. There's always people on there that I'm like, man, that person worries me. And I shouldn't have to use one of my challenges to fix the court screw up on straight up law, unambiguous, bright line rule law. But the judge makes this argument as to whether or not, if the ability existed to cure it, whether they should have to or not, isn't the issue. The issue is, when they decided not to do it, did they waive it? Now, Bernard here, he uses some language from Morrison, and it's in the dicta. Dicta is not the holding. It's not the law of the case. Okay. Dicta is something that is said in another paragraph that, like really works in terms of his argument. Okay. But it's not the law of the case. It's not the holding of the case. It's not the rule that came out of the case. So, and he also says that in that Abu-Nantambu-El case, that they punted because the prosecution didn't raise waiver. He argues that it's an open question. So in that particular case, the prosecution didn't raise the waiver. So therefore, in that case, which is on point, because the prosecutor didn't raise that in their response brief, that specific question, whether or not the fact that the defendant didn't use their peremptory to get rid of the error, since it wasn't addressed at all, it's an open question. Bernard also goes on to cite Justice Scalia, who's now deceased, in a U.S. Supreme Court case. That was called Martinez Salazar, where Scalia had written that he would have a hard time overturning a conviction where a defendant had plenty of peremptory challenges left and chose to let a challenged juror sit. So, Bernard's going up to the big dogs at the U.S. Supreme Court to pull some language that Scalia said in dicta, I'm sure. As an aside, like, you know what? I'd have a really tough time. They could have cured it. They elected not to. To me, that's waiver. So what Bernard then does in his dissent is he proposes a solution. And what he does is he adopts a Supreme Court justice, a Colorado Supreme Court justice's suggestion from that Abu-Nantambu-El case, but it came from the dissent. All right, so this is the thing that I was telling you that's really interesting about this. So Justice Samore, by all accounts, is still on the Colorado Supreme Court. Okay. And in this Abu-Nantambu-El case, he was the dissenting judge. So in his dissent, Justice Samore encouraged the trial court to grant an extra peremptory challenge whenever they deny a close for-cause challenge. So Judge Samore's like, all right, look, you guys battled it out on this for-cause challenge right here. I admit it's close. I could go either way on it. Here's what I'm going to do. Because I don't want to remove that juror for cause. So what I'm going to do is I'm going to give you a bonus peremptory challenge. That way, the defendant can use the extra strike to remove the juror. And if the court was wrong about the for-cause challenge, no harm done. No harm, no foul. Because the biased juror never deliberated. Let me get down here. So ultimately, where I land on this thing, again, I reject that concept for everything I just said 2 minutes ago. You know, despite the fact that Bernard's position sounds practical, sounds efficient, it does. And I honestly respect the intellectual honesty of it all, but I just think it's wrong. I just think it's wrong because essentially the dissent's position fundamentally shifts the burden of ensuring a fair trial from the court to the defendant by doing that. It's not our job to ensure that it's a fair trial. It's the judges. It's the role. The person with the black robe. It's one of your absolute unequivocal roles presiding over a trial is to make sure that the defendant's getting a fair trial. And to do what Bernard is suggesting shifts that burden to where now, wait, so do I get to wear a robe because I'm saving your ass because you screwed up on the law? I mean, plain and simple here, the judge made a legal error. The judge was required by statute to remove the juror. Judge didn't do it. And now the consequence of that judicial error falls on the defendant? I don't think so. I don't think so. Because as it stands now, I'm having to use one of my precious peremptory challenges to fix the judge's screw up. No way. No way. I mean, if that happens and my client's convicted, I'm coming back and appealing that issue. Okay, the law is set in stone. The judge took a break over a weekend. The judge didn't even look at the statute and came back and found that, nah, you know what? I think this juror is good. I'm not going to excuse this juror for cause. And expect me to fix it when I've got 20 other people I need to get rid of? Because again, this is not a situation where it was iffy. This wasn't like, I could go either way on that. No. If you got somebody that's 3 degrees in relation to a DA or a deputy DA that's working the case, they're gone. Boop. That's it. There is no wiggle room. It's not the defendant's issue to fix. It's the judge's mistake. And I'm just telling you, I'd be coming right back at him. Like I had to use a peremptory challenge on that juror, and I ended up getting this person on the jury because I was out of challenges because I had to use it on MB, who should have been gone for cause, who ended up becoming the foreperson of the jury and was completely biased. And I couldn't get rid of him because I had used my challenge. Now, whether or not that has legs, who knows? But I'd certainly be making the argument. Because every peremptory challenge you waste on a juror who should have been removed for cause is a peremptory that you simply can't use on somebody else. It's that simple. Yeah. And so, as far as Bernard's proposed fix on this thing, Again, asking the same judge who just wrongly denied your challenge to give you an extra peremptory just is not realistic. It's just not realistic. I want to pull up if I could find footnote 4. It's interesting. Getting there. All right, so this is where they deal with, in footnote 4, they say, although Justice Samore's dissent suggests that encouraging judges to grant requests for additional peremptory challenges under Criminal Procedure 24D3 would re-level the playing field, see Abu-Nantambu-El, we're not so sure. After all, defense counsel would necessarily premise a request for additional peremptory challenges on the court's prior wrongly denied challenge for cause, rulings made by the same judge. And we are not confident that the same judge would grant additional peremptory strikes on this basis. Because you're going to ask a judge who's already said, no, this isn't a for cause thing. And you're going up on that basis, asking for an extra, saying, you know what, I know you ruled this way and you feel a certain way pretty strongly about it, but can you still give me another challenge? Because I really need to get rid of that person because you're wrong. Does that seem like that's going to work? It's not going to work. It's not going to work. All right. So another issue. So that pretty much wraps it on why this thing was reversed. That was it. That one issue. Structural error. Sorry, new trial. That was it. Now, there were other issues that were brought up. There was a second major issue, okay, that's going to matter if this thing actually makes it to trial again. Okay. So let's see. All right, here's the warrant stuff. Okay. So Stauch's defense had argued that the warrant authorizing the search of her cell phone was unconstitutionally overbroad. Okay. And when you read the warrant alone, it is broad. It's broad in language. And for example, what they authorized in the warrant in terms of the phone was texts, emails, call logs, photos, GPS data, metadata, operating, basically everything on the phone. And the defense is arguing, okay, that's a general warrant. And the Fourth Amendment prohibits general warrants. You're supposed to be specific. We always talk about it, right? Specificity in the warrants. Can't be overly broad. It can't be just a general warrant. Like I'm always saying, warrants aren't a free-for-all. You can't come in on a general warrant where you haven't specified what you're looking for and tear somebody's house apart on a fishing expedition just looking for stuff. Fourth Amendment doesn't allow for that. You're supposed to be specific about what you're looking for. So how did the state end up winning this particular issue? The affidavit. Now, we've all come, and when I say we all, I mean you all, have come to love probable cause affidavits. I cannot tell you how it warmed the cockles of my heart to see the general public starting to care about probable cause affidavits the way that they have. There's been so many cases in the last 5-6 years where I've seen more non-lawyers digging into probable cause affidavits than ever before. I mean, any lawyer that is trying criminal cases has read thousands of probable cause affidavits. The public, up until recently, not so much. That has changed, and I love it. So that affidavit, that sworn statement, typically by a cop, that's what carried the day for the state in this thing. So you had a warrant on its face, overly broad, general in nature. But what saved the day is the cop's affidavit. Because in the affidavit, the cop went into great specificity exactly what they were looking for. So you have that supporting affidavit that's sworn by the cop. And there, the court has found that that affidavit can cure a lack of specificity in the warrant itself. And that's what happened there. Warrant was broad, but it incorporated, and that word's important, it incorporated a 4-page affidavit that described the specific conduct during a specific 40-hour window after Gannon went missing. The affidavit identified the victim, talked about Stauch's conflicting statements, her suspicious behavior, the bloody carpet, her refusal to cooperate, and established a time frame and a specific type of criminal activity. So in the appellate court, relied on People versus Rodriguez-Ortiz and held that when you read a warrant and the affidavit together, that the search is sufficiently particularized. It wasn't a fishing expedition. It was a targeted, specific set of data that was connected to a specific crime during a specific period of time. And so therefore, if this thing does go to another trial, which there's a couple of avenues that doesn't happen, cell phone evidence comes in at a retrial. So that's a relief. That is a relief. We would not want that not coming in. Got a lot of shit from the phones there in this case. So one other issue that came up is, and it's interesting. So the way that appeals work, all right, is when you have the majority, okay, which is they're the winners of the appeal as long as you have, it was a 2-to-1 majority because there were 3 judges on the panel. So those judges, when they found structural error as to that particular issue, which means, sorry, automatic new trial, conviction vacated. What that means for the majority is that they did not have to get to all the other issues that were brought up in the appeal. Does that make sense? But who did was the dissenting judge, Judge Bernard. So he had to analyze, because he was saying, all right, because even though what I've decided in my dissent isn't the rule of the case, I do have to go and address all the other issues. So because he found that waiver and he affirmed the conviction, he then has to move on. And so the prosecution had presented evidence that Stauch had been manipulative in her past in order to rebut the insanity defense. Okay. So, and that's like a common attack. There's, but look at the planning. Look at the planning that went into this. Look at the fact that they were trying to evade being caught. This person's not insane. They were doing all these things that would belie the fact that she's insane. So the defense argued that this was improper character evidence under 404B, which the general proposition is that you can't introduce evidence of prior bad acts and say, look, see, she's a shithead. She's a bad person. Therefore, she committed this crime. It's a prohibited inference. So Bernard goes on to argue that, look, and he cites cases from all different states, that when a defendant raises an insanity defense, their entire mental state is at issue. Their life history becomes way more relevant than it would in a normal trial, because the mental state is what's being argued. So in Bernard's estimation, the evidence that Stauch was manipulative goes directly to whether or not she was truly suffering from mental disease or whether she was malingering, faking it. And Bernard walks right through the 4-part Spoto test and concludes that the evidence was admissible anyway. It was relevant to a material fact, independent of character. Its probative value outweighed the prejudice. So, but here's the thing. It's a dissent. It's not binding law. But if Stauch raises the insanity defense again at retrial, the prosecution is going to push hard to get the manipulation evidence in, and Bernard just gave them a roadmap. And that's, the second bite at the apple. Everybody can tweak all the things they did in the first trial that they thought maybe wasn't as smooth as we would have liked that to have gone, or we missed something here. And that goes for both sides. I mean, I can't imagine they're not coming back again with an insanity defense. I mean, the woman's insane. She's like Satan's spawn, just sitting at the table. I mean, you're beyond damaged if you do this shit to an 11-year-old kid. I mean, the horror of it all is just beyond. It's unbelievable. So what comes next? All right. Now I've been talking about it throughout the live. Reality is that the state is absolutely going to ask the Colorado Supreme Court to review the case. And I think I saw that the DA's office already said that they're going to consult with the AG's office about seeking review. And, their feeling is that they'd be shocked or at least surprised if the Supreme Court didn't take the case, And the reason that I've been saying that the Supreme Court might want to take it is that waiver question. I mean, the majority and the dissent fundamentally disagree about whether the defendant waives a for-cause challenge by not using a peremptory challenge to cure it. And both sides acknowledged the Colorado Supreme Court has never addressed it. So it's an open question of law. And the Supreme Court of Colorado might want to settle it once and for all. And again, what makes it really interesting is what, I don't know. Like, I didn't get to this part of the research. Somebody should go out there and see if Justice Samore is still on the Supreme Court of Colorado. And remember, Samore was the footnote. He was the guy talking about the judge saying, hey, if you've got a for-cause challenge that's close, I've got a fix. If the judge refuses to strike the juror, but it's super close, the judge should give the defendant an extra peremptory so they can get rid of that juror. If that judge is on there and that judge's view has gained traction over the years, the state might see it as an opportunity to avoid what just happened at the appellate court level. And they reverse the appellate court, reinstate the conviction, and we move on. So that exists as a possibility. It's interesting. Now, if you're to ask me whether or not I think that they'll win, if the state will win at the Supreme Court level, I mean, they shouldn't. If I'm being completely candid, they shouldn't. This was a bright line rule. The judge, if Allie were here, she'd be saying the judge fucked it. And the judge fucked it. Just did. So, but on the core question of whether the trial court erred by not removing MB, I mean, all three of the appellate judges agreed to that aspect. Trial court was wrong. That was unanimous. The disagreement was about the defense's failure to use a peremptory challenge and that constitutes waiver. So all three of the justices are like, yeah, the rule is clear cut. We can all read. This shouldn't have happened. But Bernard's like, but this is where I leave you. You guys are over here. This is where the defense should have fixed this shit. And they chose not to. Therefore, it's a waiver. So it's tough. It's tough. I mean, it really could go either way. And it really depends on if that Samore is still on the bench up there. I mean, that's a factor. Because we know how that judge feels about it. He's a big fan of, on a close call, give the defense an extra, which in principle I'm against, but in practicality, as long as I'm not having to burn one of my other challenges to fix the error, maybe it's a no harm, no foul. You know what I mean? So I don't know. We'll see how it plays out. But I just want you guys to know there exists a possibility that the Supreme Court of Colorado Supreme Court reverses the appellate court, reinstates conviction, and we move on. So this is point being, this isn't destined for a retrial. It's just not. I mean, the likelihood, because we get into a whole nother conversation if the Colorado Supreme Court affirms the appellate court, that point gets punted back to the DA's office. There you go. Do with it what you will. And at that point, clearly they're going to have to retry her. Like, there's never a world in which this woman's walking out. Ever. It's just not happening. So, but I mean, there's always a plea. I just don't know what they would offer her that might get her to bite on a plea. I mean, if you watched any of that trial, you have to know that woman doesn't give a shit. She's not worried about sparing Gannon's family. She could give two shits. And if she thinks that she has another chance of not being in a prison, but instead in a mental institution, she's going to roll the dice again, even if they made her an offer. I just don't know what they'd offer. I mean, they're certainly not going to offer her anything on their watch that could ever result in her walking out of prison. It's not happening. So if it gets affirmed by the Colorado Supreme Court, I mean, it's going to, I'm guessing, going to go back to trial. And I had seen questions on Twitter and in chat about whether or not she's going to get bail. I'm in the law, you can never say 100%. No way. But I'm as close to no way as I can get. I mean, the presumption of guilt is great in this case based on the evidence. She's certainly would be considered a flight risk. She was convicted. 2 life sentences. They tried the damn case. This thing isn't getting reversed on evidentiary issues. It's getting reversed on the fact that they screwed up on the front end of it, and the whole trial was tainted. So, yeah, she's not going to be walking out on bond awaiting a new trial. So, yeah, I think it's kind of basically it. I think we've pretty much covered it all. I feel like, do you guys feel like you have a better grasp of it at this point? Do you feel that was ample? I mean, it sucks. It does. It sucks. Oh, yeah. Thank you. Thank you, Deb. Stauch. Yeah, I don't really give a shit. I'm going to mispronounce her name because she sucks. But thank you. I always do like to generally pronounce things correctly. That woman's name, I don't give a shit if I'm really mispronouncing it. Don't care. But for Gannon, I do care. So for that, I should pronounce it correctly. She's tainted the name. She's tainted the name with her awfulness. But thank you for your generosity. So it's just stalk. Like a stalker. Interesting. Love being part of this channel. Objection, Your Honor. Well, thank you. Member for 2 months. We love that you are a member of our channel. Thank you very, very, very much. Persephone, member for 23 months. OG, you are 1 month away from getting your super cool 2-year badge, which is the OG. It's the OG on the sweet chain. Because that's 2 years, you're OG. We should be able to hold judges accountable. Yeah. I mean, there is judicial oversight, but the reality is like they have to really, really suck to hold them accountable. I mean, this is just, and I think to a person, I probably watched half of that trial, if that. Again, that was, I think, back in the days when I was doing the law and crime stuff before I even had the channel. And, I think if you ask most people like the judge. Fact of the matter is the judge just shitted. Completely shit the bed. I mean, and it's devastating. It's a cautionary tale. It really is. Because in cases like this, when the appeal was filed, no one thought shit of it. This isn't like a case where we're worried about a wrongful conviction. This is a case where, like, yeah, this woman is evil. beyond all get out. Good riddance. You know, I'm sure some people were like, oh, she filed an appeal. Some people probably looked at it. No one was digging into it. Not like that. Now we know. Now we know. Andrea, thank you so much. A new member. Family hug. Welcome, welcome, welcome. Appreciate you so much. We love seeing the family grow. True Crime Addicted member for 9 months. Family hug for reaching 65,000. Thank you so, so much. It's very exciting. It's exciting. I'm so excited about the future may hold. I get some kind of super awesome set behind me. Whew, be highfalutin then. What's up? Thank you so much, True Crime, for your continued and long-lasting support. We appreciate it so much. Christine Mitchell, 5 pounds British. Bob, we love you and Allie. I wish Allie was on with me. I'm over it. Her not being with me on the lives. Over it. Totally. Thank you so much, Christine. We appreciate it. The lovely Brian. Oh, it's PB and Shelly's B-Day. All right. You know what that means. When I'm done with these, I'm just going to get a happy birthday song from me. You know how I do. You won't get the beautiful out of sync rendition that Allie and I give. It's the best. It's the best. Salty Observer, member for 7 months. Congratulations on 65K. Y'all are fantastic. Thank you so much, Salty. We love you so very, very much. Boss Tweed, New York. Family hug. Thank you so much for becoming a member. Really, really appreciate that. Oh, look at that. She likes Texas with a huge swing, gifting 20 DD podcast memberships. Wow. Thank you so much. That is so incredibly generous. And, that's the kind of gift where you just brought in 20 new family members. It's amazing. Thank you. How incredibly generous. Thank you, thank you, thank you so much. Hope Ate Fear, and she's back. I know you're in and out, but you're a long timer. I see you, Hope. But you still get a family hug. Family hug. Thank you, thank you, thank you for becoming a member again. Robin G, $5. Bob, why wouldn't Double Jeopardy kick in? That's not how it works. That's not how it works. It vacated the conviction. I mean, could you imagine? Could you imagine if Double Jeopardy kicked in on every case that was where a conviction was vacated after it went to a full trial? That's a whole nother live on how that developed. But no, it won't. It won't. Crime Curious, and thank you, Robin. The original DA on the case is running for AG right now. Interesting. Well, I don't know how that'll affect anything in the sense that the current AG is the one that's handling this particular appeal. But that doesn't mean that there'll be a different prosecutor, assuming that DA wins. Thank you, Crime. I did not know that. Kristen Vasquez gifted 5 DD podcast memberships. Thank you so much. So much. I love that you're giving on such a glorious day for our channel. 65,000 is a pretty cool achievement. For a guy who can barely run a computer, to build a little channel up to 65K, it's not too bad. I'm not doing all the things. Like, I should be putting out shorts. I keep telling Tracy, I'm putting out a short a day. Like, all the things that YouTube loves, that puts me out in the algo, that gets people that have never heard of the channel, where I'm dropping in their feeds. Like, I'm not, so it's been a pretty awesome growth arc, to be honest with you. I'm proud of us. And I'm proud of you guys for creating the best damn community on the tubes, bar none. So thank you, Kristen, so much. Robin, thank you so much. She gifted 5 DD podcast memberships. I mean, on first glance there, we got 30 new members right out the box. Amazing. Thank you so much. We really appreciate that. Mawsy, 66, member for 9 months. This is terrible for the family. It is terrible for the family. Just terrible for the family. You know, and this is a case where, like I said, with respect to the appeal, no one was looking at it. The evidence was strong as hell. It was clear she did it. You know, so this isn't like a case like where, a case like, say, for instance, Richard Allen, you know, where everybody on the other side should at least be concerned that he's going to end up with a new trial. Because there are a lot of issues with what went on in that case. This one, this is sneaky. This is a sneaky little issue. That unless you were like going through this appeal and like you kind of like pulled the statute in Colorado and you're like, oh shit, this is a winning statute. Like if Osbrook would have picked it up, he'd be like, oh, yep, new trial. You know, there's no choice in it. It's a new trial. Osbrook would have seen it immediately. You know, but for the families, they probably just got body slammed yesterday. Like, what? Wait, come again? I mean, it's brutal. It's just brutal. Just awful. And, you know, and it goes to what I was saying. It's like people kept giving me pushback, you know, because like, you know, with our coverage on, I mean, we have 200 plus videos on the Richard Allen case on Delphi, you know, and I got a lot of pushback from the guilters in that case that were all convinced that he was the guy way before trial, you know, and I'm just trying to point out all the horrible mistakes that are being made procedurally in the case. And I kept saying, man, you know, I really hope the families of the victims are watching this so they're not body slammed if he ends up getting a new trial, because what's happening in this case is not normal. And they're denying this guy a fair trial, which ultimately put guilt aside. Procedurally, his Sixth Amendment rights being violated. And I don't want them being surprised because they're getting bad intel from the prosecutors in that case, or from the cops who don't know their ass from a hole in the ground. You know, because having to sit through a trial like this or like that again, it's unthinkable, really. Thank you so much, Mozzie. Appreciate you for being a member for all those many months. Some guy with cancer. Speaking of judges, a Florida appeals court had to remove Alicia Andrews, trial judge, because she said the motion to DQ herself wasn't sufficient. Yeah. I mean, that's what I was talking about. Like, I hate that concept. I think that concept is ridiculous in terms of trying to DQ a judge for bias and they're sitting on their own shit. Yeah, I'll hear it. Okay. Nah. Curious Liz, thank you so much, by the way. Some guy with cancer, and I hope you're beating that. Curious Liz, member for 12 months. Is the state's argument burden shifting? Yeah, it's burden shifting. It's exactly what it is. I mean, it's really job shifting It's the judge's job, literally the judge's job, to see to it that it's a fair trial. And when you've got a hard and fast rule, I mean, frankly, the judge should have all of those rules committed to memory for every trial, because it'll always be a thing. I mean, they put the questions in the jurors' questionnaires for a reason, for exactly this situation. To be ignorant of the rule is frankly unforgivable. If I'm Gannon's family, I'm furious. Furious. Thank you for your continued support, Curious Liz. We appreciate it. Ain't So Plain Jane gifted 5 DD podcast memberships. Thank you so much, Ain't So Plain Jane. We really, really appreciate that. And we adore you. We do. Mark Cunningham, member for 5 months. Bob and Allie, have a great Easter. Y'all too. We're getting to see the grandbaby, so it'll be amazing. Faux show. Excited about it. Love it, love it, love it. She's 2. Gonna be running around cute as all get out. Just went and got her a nice little fuzzy Easter basket. I'm like, does she eat candy? So I'll buy her some candy. It's Easter, for God's sakes. So I hope you all have a happy Easter, happy Passover, whatever you may be celebrating out there for sure. And Janine Joe, new member. Family hug. Family hug. Welcome, 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 welcome. All right, let's see. I might have just one more order of business here. Let me see. Kim, our daily Venmo angel, thank you for your $25 Venmo. We really appreciate that on this glorious day, celebrating our 65,000 mark. Thank you for that so much. We appreciate you. Wait, let me check, make sure just so nobody else sent anything on the good ways to send things. Oh, got some cash apps. Oh, the beautiful, beautiful Pammy. Wow. Pammy sent $65 via Cash App for our 65K. You are the best. We love you, Pammy. I missed you very much during Corey Richens, by the way. And I know where you were, but I'm not holding it against you. I just want you to know I knew you were missing because I love you. Thank you so much. We truly do adore you, Pammy, so very much. Incredibly What do you need? I'm wrapping up. Why?
Because I can ask you something real quick if you want to.
No, yeah, I'm wrapping up. I'm wrapping up. Allie's trying to pull me off alive.
No, I just needed to ask you something.
You want to sing happy birthday with me to PB and Jelly real quick?
Yes.
All right, let's go. All right, to PB and Shelly. Ready? 1, 2, 3. Happy birthday to ya. Happy birthday to ya. Happy birthday to ya. Happy birthday to ya. Happy birthday. Hey, happy birthday, PB and Shelly. We love you. I hope you're still here and you got to hear your rendition. We love you. We love you. And everyone else that has a birthday, anyone else that we may have missed, that was dedicated to all of you because we love you so, so very much. And Music to My Soul came in with, I'll accept a family hug. And or is it your birthday too, Music to My Soul? And you know how much Allie loves your screen name. Family hug. Yeah. That's for you. And happy birthday. Happy if it is indeed your birthday. Birthday twins. That went out to everybody. Everybody who's celebrating either today, tomorrow, Sunday, all the days. All right, you guys. Wait, I'll just check one more thing. When is Scarlett's flight back, by the way?
Tomorrow night.
Oh, in the evening. Okay. All right. I've gotten good news. Well, I'm dying to see Scarlett, so it's good. It's good-ish news. I think I'll have time to squeeze in a Zach Adams tomorrow. So I'll probably do like an hour, couple hours on Zach Adams. So keep your notifications button, hit that bell. You guys are amazing. I love you so much. Again, thank all of you for making this community amazing. Thank you for helping us grow.
Thank you, everybody.
Yeah, it's just, it warms our hearts. It warms our hearts. If you haven't read it, go to the community page. I did write a love letter to all y'all, and I mean every word of it, truly, truly, because you guys really are the bee's knees, truly. To my mods, I love you guys. Thank you for all your incredibly hard work. You're the backbone. I'll be down in a second. You're making, like, when you pace behind the thing, it's squeaking. You guys are just amazing. Thank you so much for all your hard work on a daily basis. And please, I hope that we've been dropping the tip jar for our mods in the chat. Buy them a coffee. We're going to spread the love to our mods who work so very hard. And, you know, it really means a lot to them. It means a lot to us to give a little love to the people that make that chat amazing. They make it safe. It's a safe space for everybody. It doesn't matter what your opinion is. They'll just remind you. If you're acting like a little bit of an asshole, they'll be like, you know what? Keep it clean. You're allowed to disagree all day, but don't be an asshole. That's what you thank the mods for. They're amazing. You're the best. I love every single one of them so much. So much. And you guys, to all of you out there, oh, my birthday on 4/1. Nurse Hannah, that definitely went out to you as well. And you guys got the full, actual, synced up version of Stevie Wonder's amazing happy birthday song. So we love you. Happy birthday, Nurse Hannah. All right, so that's it, y'all. I love you guys. And just remember, deep, deep, deep down into your soul, that if it wasn't for you guys, I'd literally just be an old man talking about a lot of cases. Thanks for getting us to 65K. We love you.